My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate the public, so please subscribe to our channel. What do you do if you file for divorce and your spouse doesn't respond to the divorce papers? Doesn't answer them, doesn't take any action, it just does nothing. Well, the law gives a spouse who served within the state of Michigan a certain amount of time to answer. So you got 21 days anyway, so you got to wait out that time. Now let's assume that after that period passes, still nothing is done. Well, you've got to take some action, because if she does nothing and you do nothing, eventually the court's just going to dismiss the case for non-progress. They're going to say, nobody's doing anything, so we've got to dismiss this. It'll have an impact on the case in that if she doesn't answer, you'll be then proceeding by default rather than by a case where her input comes in. So when that happens, what first has to be done is, if the person doesn't answer, an application has to be filed for a clerk's entry of default. It's important to file a request for default, because if you don't, like I said before, the court may well think that you are also abandoning the project. So you got to let the court know, no, I'm interested in this, I want to see it through to the end. You have to request a clerk's entry of default. The court clerk will enter that default after the time period passes. It's not over yet, though. The divorce case, it really isn't over until the court enters a final order of dismissal or a final judgment of divorce. So that means, since your case is going forward, you've still got to enter a judgment of divorce. And that means you have to contact an attorney. You've got to make sure that your attorney knows to prepare the judgment. That attorney's going to have to reach out to the other side, even though the other side hasn't answered. There should be an effort made to try and get an appropriate response from the other side. Now, maybe they didn't get the service somehow, or maybe they didn't know what they were supposed to do. It's not the job of your attorney to educate them, but at the same time, if your attorney is going to, for example, apply for a default judgment, there are certain service requirements that the law has. There are certain obligations that have to be met in order to properly perfect a judgment of divorce by default. Now, you might say, well, it's a default. What's the difference? The other side's not appearing. Well, the thing is like this. You don't want to get a judgment of divorce by default, presume that everything's fine and that you're all done, and then have the other side file a motion to set aside the default on the basis that they weren't properly served, or they didn't get appropriate notice of the default, or who knows what. There's a lot of reasons why they may move to set aside the default if justice so requires. So, in other words, you want to bring finality to the case. And if you want to bring finality to it, you better make sure that the default is properly entered and that the ensuing default judgment is properly noticed and entered, so that the thing will be over and you won't have to worry that somebody will move quickly to set it aside. If you have any questions about that, reach out. We'll be glad to help you out.